Now, my lords, this provision cannot be the pretext for what counsel for the first respondent seeks to do, namely preventing cross-examination of a witness who has already submitted a witness statement before this court. And that witness statement was submitted based on, it was submitted on the 22nd of January 2021, based on the orders of this court at the case management stage. It's our respectful submission that by filing its witness statement, the first respondent has clearly crossed the bridge as far as opening the witness up for cross-examination is concerned. That bridge has been crossed. That ship has already sailed. My lords, in determining issues regarding leave for serving interrogatories on first respondent.
Please, Mr. Tsikata, before you have referred us to Order 36, before you go on,
yes, my lord,
I want you to read Order 38, Rule 3E, Sub Rule 5 of CI 47 as amended by CI 87. That is in respect of written statements. Order 38, that is in respect of witness statements. Order 38, Rule 3E, Sub Rule 5. You can read Sub Rule 1 before you go and read Sub Rule 5. Then you appreciate the import of the rule. Of CI 47 as amended by CI 87.
Yes. Order 38, Rule 1.
Rule 3E.
3E 1 and 2.
Rule 3E 1 and 5. Rule 3E,
yes.
Sub Rule 1 and then Sub Rule 5. That's the CI 87.
Yes, 3E1.
Yes.
If a party has served a witness statement and that party wishes to rely at the trial on the evidence of the witness who made the statement, that party shall call the witness to give oral evidence unless that party shall call the witness to give oral evidence, shall, unless the court otherwise orders, unless the court orders otherwise, or that party puts a statement in, that party puts it in as hearsay evidence. So in fact, it is that party. Yeah, but my lords, let's be just clear about what one says, because one does not advance anything as far as, but
you read 5 in addition, so that
now 5 reads. 5 reads, if a party who, I'm sorry, is it 5 or 3F? 5. If a party who has served a witness statement does not call the witness to give evidence at the trial or put the witness statement in as hearsay evidence, any other party may put the witness statement in as hearsay evidence. Now, my lords, this is why I was going to advert your minds to various statements made in affidavits of the chairperson of the first respondent in connection with that very matter. And my lords, I believe that if you will allow me to proceed with the order of my submissions, I will explicitly address whatever concerns you have about CI 87 and its impact. Because, my lords, we're dealing with a situation here where, in determining the issues regarding leave for serving interrogatories on the first respondent, the fact that what was in the interrogatories could be the subject of cross-examination was a critical aspect of what was urged on the court by first respondent. There was an affidavit filed on 22nd January 2021 by the chairperson in opposition to a motion for review of the court's refusal to allow for interrogatories to be served. And this is what she says in paragraph 7. The applicant, referring to the applicant for review, the applicant does not suffer any injury at all to his rights. Paragraph 7. The applicant does not suffer any injury at all to his rights if the court dismisses the review application, as he still has the opportunity to solicit the answers he seeks during cross-examination if he so wishes. This is the chairperson in her affidavit, stating that the applicant does not suffer injury as he still has the opportunity to solicit the answers he seeks during cross-examination if he so wishes. There is another affidavit on the 25th of January 2021 by the same chairperson, 25th of January 2021, by the same chairperson of the first respondent in an affidavit in opposition to our motion for stay of proceedings. And there she states in paragraph 5 as follows: the petitioner does not suffer any injury at all to his rights if the court dismisses this application, as the petitioner will still have the opportunities to solicit the answers he seeks during cross-examination if he so wishes. These are statements of the chairperson who is now seeking to evade being cross-examined. And she puts, the first respondent puts it beyond doubt that she herself knew that cross-examination was imminent in terms of the processes of the court. So our submission is that the combination of the filing of the statements, so it is a combination of the filing of the statement and the clear statements in the affidavits that we have quoted from, that makes clear her own intimation to this court that she would be subjecting herself to cross-examination. That is clear in her own words, under her own hand. And my lord,
Mr. Tsikata, can't she change her mind?
Well, my lord, there ought to be good reasons. There ought to be good reason for changing her mind. And my lord, yes. My lord, indeed, my lord, if she changes her mind, that should be openly put to this court, and the court may have power to disallow that change. Yes, my lords, and I will, my lords, if your lordships will allow me to, because...
Are you implying that by this affirmance in the affidavit, she is stopped from saying that she will not give evidence? Is that your...
That is correct. That's
the argument?
Yes. She has made representations to this court and to other parties in this case, specifically to the petitioner. She has made those representations, and she cannot now resign from those representations unless there's good reason. My lords, I will come to the issue of where there is good reason for anything. the court, as your lordships did when there was paragraphs 1 to 17, when it was obvious, where there's good reason for something to be done, of course the courts.
There was good reason there, but there's no good reason here.
That is what I'm submitting, because it has not even been put forward to you. In that particular case, the good reason was because the witness himself had noticed that there was a mistake in the statement of truth. The statement of truth is basically a format, from the solicitor's office. And the witness had signed the 1 to 32. He had not signed the statement of truth, but the statement of truth made a reference to paragraphs 1 to. So I made an application for an amendment. So that is a completely different situation from what we have.
Mr. Tsikata, 1 minute.
Yes.
Is there a reason why a witness should mount the witness books?
Yes, my lord, there's a lot of reason.
Yes.
Especially when that witness is the declaring officer with a constitution.
I'm not even narrowing down to the first respondent.
My lord, in
this whole hearing, because witnesses file statements, and we don't take them on the face of its value. They have to mount the witness box, swear an affidavit to the effect that swear an oath to the effect that what is contained in my witness statement, is the truth. Until that is done. Otherwise, as soon as you file a witness statement, then you go on cross-examining.
My lords, we're dealing with the specific circumstances of an election petition under the terms of CI 99, which your lordships have sometimes used to strike down the operation of CI 47. And
that this is a case that is different from all other cases?
Your lordships have said so, that CI 99.
But what is there in CI 99 that suggests that witness statements automatically become statements on oath?
There is in fact nothing in CI 99 about witness statements, as your ladyship knows. There is nothing about witness statements. This is being imported from CI 47, and that's part of the issue that we're having.
And so that makes witness statements automatically statements on oath?
My lords, the tenor of the witness statement, as well as the answer in an election petition. My lord, in a normal statement of claim in a high court, you don't have the plaintiff having to sign and having to verify in an affidavit. You don't have that.
But in matrimonial petitions, yes, you do.
Yes.
This is just a different form, and that is replicated along the journey. Along the journey of commencing cases. Some come in originating motions, some come in petitions, some come by writ. Each one has its character. That's all. All?
That's not all. Your lordships have said otherwise. Your lordships have said that an election petition under CI 99 has special characteristics. And that is part of...
Yeah, so Mr. Tsikata, that changed the law on witness statements. Because we know witness statements are potential evidence.
My
potential. Lord. That is why the statement of truth is there. So long as it is not sworn, it's not a sworn statement, it can't be evidence.
My Lord.
And you know, judicial decisions are based on evidence.
My Lord.
Judicially taken, where the witness comes to the box and takes the oath.
My lords, this is why I'm drawing your attention to the difference in the election petition case, where the answer, the petition and the answer are signed. In this case, the chairperson signed the answer and signed a statement of an affidavit of verification. And not only that, she also signed the witness statement with a statement of truth.
as her
No, my
potential,
lord,
as
my
a
lord.
potential evidence.
It's not potential. My
It
lord,
is, because it's no evidence.
My lord, it is not potential evidence, and I shall.
They are generic forms.
We have to agree on that before we can proceed.
Very well.
Whether or not a witness statement is evidence.
No,
Mr. Tsikata, if you look at
my lords, that's not what we need to. We ought to agree whether the filing of a witness statement means an election to adduce evidence. That's what we need to agree on. If it's an election to adduce evidence, that
if
is
you look
the
at
precondition. Is it an election? That's what we have to agree on.
Can you look at Order 38 Rule 3E2?
Now, my lords, it would actually have been useful.
Please, can you look at that? Can you look at that so that
very
we can?
well. It would have been useful for me to respond to what they provide.
No.
And then you can put, but very well, 38 Rule 3, 38 3.
3E2.
3E2. Rule Order 38.
The same rules that were the two. The same rules that we were earlier
so
on
this
referring
is
to.
CI 87.
87, yes.
Very well.
38 Rule E, 3E, sub Rule 2.
Now this is your lordship is referring to CI 87.
87, yes. 87.
And this is under general rule. Is that it?
No.
Use a trial of witness statements.
This witness statements. So let me read.
Page 4.
Where a witness is called to give oral evidence under sub Rule 1, the witness statement of that witness shall stand as the evidence in chief of that witness unless the court otherwise orders.
Yes.
So it is only when the person is called upon to give evidence, then his witness statement becomes his evidence in chief.
My lords,
the mere filing of a witness statement does not constitute evidence.
My lords, it constitutes an election. My lords, it's very clear, Order 36, which they are relying on. It says, where the defendant elects not to adduce evidence. And my submission has been that they elected by the witness statement, by the affidavits in which she said so, and I will quote more affidavits of hers. So it is the election to adduce evidence.
Assuming we're not doing trial by witness statement, and the defendant comes to court.
My lords.
Mr. Secretary, please, a defendant comes to court, and he says that he's going to call, he himself is going to testify and call 5 witnesses. And at the end of plaintiff case, he decides that, my lord, I'm not going to lead evidence. Neither am I going to call witnesses.
My lord,
would he be barred from saying so? Because he has initially informed the court that he himself was going to testify and call 5 witnesses.
My lords, that is why I said that it depends on the context. In this case, we're dealing with a context of an election petition with its characteristics, and we are saying respectfully that in the context of the election petition,
yes,
where the petitioner has put in a petition, the petitioner has put in a statement of verification, an affidavit of verification.
Yes.
You have the answer, and this chairperson signs the answer on behalf of the first respondent. And after signing that, she also signs a number of affidavits.
So, Mr. Tsikata,
and so
the petitioner in this case has signed a petition.
Yes.
Can he be compelled to come and give evidence?
My
The
lord,
petitioner.
who will compel him?
He has almost deposed almost deposed to all the affidavits from,
but
from
my
your
lord,
side.
that is not the point. Who is going to compel him?
What is good for the petitioner issued the
petitioner has
petition?
not filed a witness statement.
No, but
has the petitioner filed a witness
he
statement?
has filed a petition. He has deposed to several affidavits. Can we compel him?
The petitioner has not filed a witness statement.
What is more great than a petition? Mr. Gita, what is more great? What is more serious than a pleading and a witness
My
statement.
lords, it's not a question of what is more serious. It's a question of what the rules.
No,
the rule says where the defendant elects not to adduce
Yes, I'm
evidence.
saying that you are addressing us. You've referred to several affidavits deposed to by
Yes.
the chairperson or the first respondent. And I'm
Showing
saying
that-
Mr. Kita, I'm saying that in the same vein, the petitioner has deposed to several affidavits before us, but we cannot compel him to
In
come and give
no,
evidence.
in no affidavit of the petitioner does she say what I'm going to be subjecting myself to cross-examination, and therefore you don't need to send me interrogatories. Nowhere has she done as the petitioner.
Mr. Tsikata, I'd like to say, Mr. Tsikata.
Well, can I answer one at a time?
Very well, very well, very well.
Yes, my lord, the petitioner has nowhere said that I am going to present myself to cross-examination and then reside on that. The petitioner has never said that. In fact, the petitioner has not filed a witness statement. The petitioner is relying on his witnesses, which is entirely allowed. So, my lords, nobody can compel him to come and say. And what the point that I was making in respect of what is in the affidavits of this chairperson is that she herself, in opposing an application in respect of serving on her interrogatories, she deposes to the fact that she is in effect going to be available to be cross-examined. She says that. I read the affidavit. There's nothing equivalent to that in the affidavits of the petitioner. Nothing. And there cannot be a legitimate comparison between the status of the petitioner and the status of the chairperson on the basis of that. That it cannot happen. The logic of the situation should compel us to only one conclusion. The affidavits that I'm reading, and I will read some more affidavits of hers before I'm done, those affidavits state clearly her disposition to be cross-examined. And she uses that as a basis for opposing the leave for interrogatories application. She uses that. So you can't discount that. And nothing that the petitioner has done in an affidavit, nothing compares to that.
So, Mr. Tsikata, all that I'm saying is this. If a party comes to court and informs the court that he's going to give evidence himself and call 3 witnesses, and later on he changes his mind, that because of certain things that are happening, I don't intend to lead evidence, neither do I intend to call witnesses, is the party bound? Or can the court compel that because of the statement that he made?
My lord,
Can he be compelled to testify?
my lords, what I've stated clearly is that Order 36, Rule 4.3 is clear in its terms. Where the defendant elects not to adduce evidence, and so and so. And my lord, I have said that in this case, this respondent, this first respondent, has elected, and he's elected both by filing the witness statement, and also he is elected by her affidavit, in which she was rejecting our request for certain information to be provided by her, and she was in effect saying to us, wait, when I'm being cross-examined, you can put it to me. That's the effect of what she says in her witness, in her affidavits. That's the effect.
So he can't change his mind.
Yeah, my lords, that's why I said if she changes her mind, there are proper ways to effect that. At the moment, we do not have that situation. And my lords, I will respectfully further indicate that the dispositive part of Order 26, Rule 4.3 has nothing to do with what is being done before you. That dispositive part just says the plaintiff may, after the evidence on behalf of the plaintiff has been given, close the plaintiff's case And the defendant may then state the case of the defendant. That's the dispositive part. It has nothing to do with what has been done.
I think my brother on my right referred you earlier on to Order 38, Rule 3E5, who deals specifically with witness statements. CR 87, who deals with specifically with witness statements. And the interpretation that we can put on is that witness statement.
Yes, my lords, the 5.
So the witness has gone to the witness box and taken the judicial oath.
My lords, with respect, that is an erroneous interpretation.
No.
With respect, what that rule reads is if a party who has served a witness statement does not call the witness to give evidence at the trial or put the witness statement in as hearsay evidence, any other party may put the witness statement in as hearsay. So the dispositive part of that is any other party may put the witness statement in as hearsay evidence. That's the dispositive part.
So it allows a party not to call a witness who has filed a witness statement.
No, my lords, that cannot be the proper interpretation. It says if a party, my lords, it says if a party who has served a witness statement does not call the witness to give, yes. My lords,
Don't decide not to call.
My lords.
And please, Mr. Tsikata, in your rate, relief 4, the number of witnesses that the petitioner intends to call, 5. Eventually you call 2, and then you, with leave of the court, you add 1. But were you going to insist that because you've written in your rate that you will call 5 witnesses, go and bring the 5 witnesses?
No, my lords, that is not the same situation. We had not filed 5 witness statements. We had not filed 5 witness. My lord, the matter is very clear. We had not filed 5 witness statements. So that analogy does not hold with respect.
But I've already told you that, yes, the witness statement may be filed. But until the witness enter into the witness box and swear an oath, it is not evidence yet.
My lords, this is not the position that was taken by the Supreme Court in a case Sumaila Bill versus Adamu Dramani and the Attorney General. That position that your ladyship has expressed was not the position taken. And may I? It is, as far as I know, it's unreported. It's written number
no,
J.
It's reported.
Very well. I don't have the report, but I have the ruling.
I think 20, I'm not going
My lord, may I read from? May I read? Yes, but my lord, may I read and then we can discuss what the impact of CI 87 is on that matter.
Okay, so
read number J1/2/2010. And the ruling is delivered on 23rd May. Yes, my lord, it's 2012 1 Supreme Court of Ghana law reports at 370. And my lords, I'm well aware that CI 87 was not in force at that time, but CI 47 was in force. And my lords, the portion of His Lordship Justice, and my lords, it was a panel that consisted of Dr. Datseban, Justice of the Supreme Court, Ansa Adinyra Owusu, Miss Doche Yeboah JSC, as your lordship then was, as you were then, Bafu Boni JSC, Badegbe, and Akuto Bamfu. And my lords, this is what, no, that's not very important. That's not important. No, it's not. Well, there's a series of these cases. That report, the law report that I refer to refers to another of the bill cases. As your lordship knows, there's a series of bills. So, my lord, let me stick with my writ number J1/2/2010, a decision delivered on the 23rd of May 2012. And in that, this is what Dr.
This is the correct. The citation is page 37.
So the citation is 374 rather than 370. If we're taking it from the Supreme 174, 2012. And this is what Dr. Datseban says in the ruling of the court, which included your lordship, the Chief Justice. It is a unanimous view of this court that the first defendant, Adamu Dramani, should be called upon to open his defense in the interest of justice. This case does not have the ordinary characteristics of a trial, say at the High Court. The procedure before this court is such that before the commencement of oral testimony in this case, the first defendant had already put matters in evidence by affidavit. In this circumstance, it is artificial and hardly sustainable to disregard the evidence already adduced by the affidavit of the first respondent and proceed to an assessment of a no-case submission made on his behalf as if the only evidence on record is that of the plaintiff. So, my Lord...
Mr. Tsikata, please. We are dealing with witness statement, which is not sworn. You are talking about an affidavit that is sworn.
And I refer to...
So it's affidavit evidence.
I refer...
A witness statement cannot be evidence. That is where we depart.
My Lord...
Affidavit is evidence because it is sworn before the Commission of Oath.
My Lord...
Witness statements are not sworn.
My Lord, in this case, well, witness statements are also verified as statements of truth.
No.
Yes, but my Lord...
That is why we allow you...
My Lord... Yes, but my Lord, I refer to affidavits sworn to by the chairperson. I refer to affidavits. No, but those... But my Lord, the ruling of this court...
The issue between you and me in particular is that as far as, for me, we take the judicial oath, the oath to speak the truth, for her to be cross-examined, for the witness statement to be adapted as evidence in chief. That document is just a potential evidence. It is not proper evidence before this court because it's not on oath.
My Lord,
we cannot rely on it.
My Lord, that evidence indicates an election to adduce evidence. My Lord, that is what I'm submitting.
So it is evidence.
It's an election. My Lord, I'm saying that
okay.
The rule that we're dealing with talks about election to adduce evidence. And I'm saying it's an election to adduce evidence. So my Lords cannot keep going back to the issue of whether it has been, sworn or not, because the order that we are dealing with, according to the argument of counsel for the first respondent, is an order where he is reading where the defendant elects not to adduce evidence. That is the material basis on which he is putting forward his submissions to you. And your lordships are taking me away from the language of that order where you elect to adduce evidence, and your lordships are going into an issue of where he has called the evidence. But those are two different scenarios. Because if he has elected by virtue of the witness statement and affidavits that he has filed, if he has clearly elected, then that Order 26, Rule 4.3 cannot apply because of his election. That's the point I'm making. So the dispositive part of 36, Rule 4.3, that dispositive part will not come into operation. And I'm saying further that in any case, that dispositive part of that Order 36, Rule 4.3 does not have the consequence that he's attributing to it. And I'm further submitting that all these questions about whether this particular witness state, or whether in general terms a witness statement means that he cannot change his mind or not, all those do not address what the terms of Order 36 are. Because Order 36 is talking about electing not to adduce evidence. Electing not to adduce.
May I seek a clarification, and maybe it will help us to move forward. So, if I understand your submission, it is that an election has to be made by the party. Mm-hmm. Now, your submission is that the first respondent made this election from when they filed the answer and other affidavits that they have introduced and things. So is for you.
The witness statement.
Yes, and the witness statement. Can I then say that the key issue is what constitutes the election and at what time can it be made?
Absolutely.
And can what the first respondent is doing now constitute an election now rather than the previous thing? That seems to me to be the issue that we have.
I agree 100% that is the issue. That is the issue before us.
It's simple.
And my lords, what I'm submitting is that as at the time when this application was put before you yesterday, as at that time, the election that had been made was contrary to that precondition in Order 36, Rule 4.3. Because that condition said, where the defendant elects not to adduce evidence. And by that time, when he got up to say what he said, they had already elected to adduce evidence. That is my submission. That is, well, my lord, that determination has to be made on facts. And the facts that are before all of us in plain view are that they have filed a witness statement, the chairperson, and she has filed various affidavits in which she says she's offering herself for cross-examination basically on the assumption, and not an assumption, she's actually saying, I don't want to have to answer interrogatories because I'm available for cross-examination. That's what she's saying. And I'm saying that affidavit upon affidavit which deposes to that, affidavit upon affidavit which deposes to that constitute representations of her election to testify, her election to undergo cross-examination. That is my submission. Yes.
The point I needed or I wanted to you to address is the point at which here witness statements are filed. It is done at the case management stage, when the court directs that parties should file their witness statements. This case management stage is a process for ensuring that the case can move expeditiously. Is that not the situation? So with that direction, following that, no party can change their mind.
Well, they can ask for leave to. They can ask for leave where they need to change their mind. They can ask for leave.
Thank you.
In this case, we do not have an application for leave. In this case, prior to what was represented to you yesterday, as at the time that my learned friend got up to make his submissions, as at that time, my submission is that there had been an election to do the opposite of the precondition in Order 36, Rule 4.3, where the defendant elects not to adduce evidence. And respectfully, all the material that is before this court in plain view, as I indicated, all that material is that there was an election to testify. There was an election to adduce evidence. And that was also included. That was also included. That's it. That election, yeah, page. Yeah. I will. Right in. Okay. Yeah. My lords, another significant passage in the decision in Biel and Dramani is a passage at page 377, where after referring to the English authorities, including Alexander and Rayton. Can I have back my? Yeah. Okay. Yeah. Okay. Where after referring to Alexander and Rayson, in particular, the passage where the court had said that it is not right that the judge of fact should be asked to express any opinion upon the evidence until the evidence is completed. His Lordship, Justice Dateba, continues. Similarly, it is an inherently difficult exercise to ask this court, in this case, to disregard evidence put in play by the first defendant's affidavit and to rule on his submission of no case as if the only evidence on record is that of the plaintiff. That is why we consider that the interest of justice would be best served by hearing whatever evidence the first defendant wishes to offer in his defense. The interest of justice would be best served by hearing whatever evidence the first defendant wishes to offer in his defense. This court can then make up its mind in relation to all the facts at the end of the trial. My lords, respectfully, this wisdom of His Lordship Justice Dateba is particularly germane to this case, where it is the chairperson of the Electoral Commission who is not only the returning officer, but in whose bosom resides the basis on which she made her declaration. It is in nobody else's bosom, not even in the bosom of your lordships. It's the law that is in your bosom, but in respect of the declaration, your lordships, it is only in her bosom that the basis of the declaration can be found. And so, where she has elected to give evidence before you, we cannot have a misapplication of Order 36, Rule 4(3) as a reason for her not doing what she has told us in a sworn affidavit she's ready to do. She cannot do that. The God to whose glory she announced she was doing what she was doing is a God of truth. And therefore, my lords, it is important to bear in mind what Justice Dateba said. And in this particular case, he actually goes on to cite what he calls the sound advice of Lord Justice Simon Brown in the Benham case cited above, where he says, "Let me state my central conclusion as emphatically as I can. Rarely, if ever, should a judge trying a civil action without a jury entertain a submission of no case to answer." That clearly was the court's conclusion in Alexander and Rayson, and I see no reason to take a different view today, the CPR notwithstanding. Almost without, and that is a reference to the CPR, of course, in England. Almost without exception, the dangers and difficulties involved will outweigh any supposed advantages. Any temptation, that's the last word, any temptation to entertain a submission should almost invariably be resisted. Now, my lords, it is therefore my submission the lordships are comparing. My lords, my respectful submission is that exactly as in the Bill decision of the Supreme Court, the interests of justice, at a minimum, require this court to do exactly what was done in the Bill case.
Tsikata, sorry for interrupting your submission. In that case, if my memory serves me right, they have come to court and made a submission of no case. And what we read was a ruling. In this case,
there's no submission of no case.
Yes, they are opting. It's an option. They are electing not to give evidence. So let us be very clear.
Yes, my lords, My lords, I'm very clear in my mind about what happened in the Bill case. I'm very clear in my mind about that. And I'm very clear in my mind that in that case, the plaintiff went to court seeking an enforcement of a provision of the Constitution in respect of the eligibility, exactly, the eligibility of
an MP.
Parliament. Yes. And my lords, in that case, as your lordship rightly said, there was a submission of no case. But my lords, the reasoning, the ratio decidendi of that case, in my respectful submission, is based on what the interests of justice require, where a plaintiff has deposed to an affidavit. And in that case, it was only one affidavit. And their lordships were saying, their lordships, including your lordship, the Chief Justice, said clearly in that case that in the interest of justice, the defendant should testify. That's what your lordship said. And I'm respectfully submitting that that ratio is a ratio that is worth applying in the circumstances of this case. The only difference in the circumstances of this case is that they are relying on Order 36, Rule 4.3. And in my submission, that Order 36, Rule 4.3 does not lead to what they're asking for, because...
Please, I want to correct us. They are relying on Order 36 and Order 38. Please don't leave Order 38 out, because Order 36 has nothing to do with witness statements. Order 38 is specifically crafted for witness statements. And you are avoiding that.
My lords, I'm not avoiding that. My lords, if your lordships are with me that Order 36, Rule 4.3 is irrelevant, then, my lords, I will indeed address directly what your lordship is claiming that I'm avoiding. I cannot be said to be avoiding it when I referred your lordships to that Rule 5, and I said respectfully that the interpretation that your lordship was putting on that was not, I believe I responded to that. So how can your lordship on the other side say that I didn't respond, I'm avoiding 38.5? I responded to your lordship directly. My lords, I don't think it's fair to me to be making that sort of observation.
Another difference, another significant difference.
But my lord, can my position be accepted that I responded to your lordship?
You did.
Yes. So how can my lord say that I'm avoiding a particular provision? So that's not right.
Yeah. I just want to draw your mind. Another significant difference in the case you cited, the Bill case, is that dealt with affidavits. Dealt with affidavits. The court dealt with affidavits, which are generally evidence, because they are sworn. But in this case, we are not dealing with affidavit. So that is another significant difference,
my lord.
I want us to...
My lords, with the greatest respect, that is why I took the pains to refer to affidavits that are before you in these proceedings. In the same way as an affidavit was before the court in those proceedings, I have referred your lordships to affidavits which are before you in these proceedings.
But these affidavits are affidavits attached to applications.
Yes, but they're still before you. They're still before the court, my lords. I mean, affidavits attached to applications are before the court. Is that not interlocutory? That is why when people say affidavit, they say I refer to all the processes as if I included them in the affidavit. I mean, that is, I would have thought, a basic aspect of
in writing a judgment, in writing a judgment or a ruling,
yes,
would a judge be right if the judge went referring to affidavits attached to applications,
my lord,
and left the record of the testimonies and the cross-examinations that the judge received? Would you, in writing a judgment, would a judge be right, ever right, in referring to affidavits attached to applications
Yes.
that had been completed?
Yes, my lord, the judge, I not ignore. I never said that they should ignore. I said that you can refer to those affidavits. My answer to your specific question, my lady, is that you can, for instance, if something that was in testimony is contradicted by something that she filed in affidavit, is filed in affidavit on oath, that is a matter that can be referred to, and that is a matter indeed upon which there can be cross-examination. There can be cross-examination on those matters. Because
That's mixing. That's totally mixing.
totally what?
Mixing. If you have interlocutory applications and they're done with, you can mix them with the evidence taken at trial.
My
You
lord,
know that.
It's not a question of mixing them. You always have available a record. And if in that record there are affidavits in which statements have been made, they are on oath, and you are entitled to refer to them. That's exactly what their lordships did. In that Bill case, it had not got to the, I mean, what was stated in the affidavit has not been stated in the witness box. What was stated in the affidavit had not been stated in the witness box.
It's a trial on affidavits. In the Babel case, trial on affidavits.
Yes, but that's what I
So they were perfectly right. My laws were perfectly right.
But is your lordship saying that if the witness had gone into the witness box and had said something contrary to what they said in the affidavit, for instance, if the court had ordered that we want to hear you, just as the court ordered the defendant to go into the witness box, the court could have said, we want to hear your evidence in the witness box. Is your lordship saying that you cannot refer to that affidavit which is deposed?
So even in the affidavit trial, a deponent can be ordered to appear, to be cross-examined. So it's a trial.
That's what happened. But that is what happened.
Because that affidavit is evidence. So you can be cross-examined on it. But we are saying that in a witness statement, it is not yet evidence. That is where
my lords, I don't think the issue that we are dealing with right now should really be the issue of whether it is yet evidence. Because I believe yes.
That is agitating my mind. That is what's agitating my mind. Whether it is evidence or not. And the mere fact
is that Order 34, as cited by counsel, is not relevant in the current circumstances. That's what you're saying.
Is that what your ladyship is saying?
No, that's what I understand you are saying.
That's what I've been saying.
Order 36.
And I believe that is what was summarized by
my brother.
Realize different members of the bench are agitated by different things.
Absolutely. And I'm seeking to address the different things.
Yeah.
I'm seeking, and I appreciate the fact that your lordships are candid with your concerns. I appreciate that entirely. And so, my lords, the point I'm making, if we move away from Order 36, Rule 4.3, if we move from there into the question of what is the effect of a witness statement, which is what is agitating your lordship's mind. What is the effect of a witness statement prior to when the witness actually goes into the witness box? And my lords, my submission on this is very straightforward. My submission on this is that your lordships made case management orders in this case in respect of how the case would proceed, including the witness statements and the witnesses. Now, my lords, it is my respectful submission that nowhere in either your case management orders or in CI 99, nowhere is there provision made for the procedure that my learned friends are seeking to adopt. Nowhere in the rules. Nowhere in the rules. Now, your lordships have been referring to Order 38(3) as amended in CI 87. And in that order, 38 rule 3E, the provision again is very clear. If a party has served a witness statement and that party